around the trademarking and intellectual property rights when it comes to this colloquial term that we've all been using, but apparently we're not supposed to be using. There's been banter online all the week long about the fact that there's a founder who says that she coined this phrase and she's trademarked it, yes, and the rest of us can't use it. So we're in conversation right now with Luyanda Maema, who's a candidate legal practitioner at PPM Attorneys, to chat to us about IP and trademarking when it comes to just viral trends and, our lives. Good afternoon, Luyanda.
Good afternoon.
So
Very good to be with you both.
this is
Thank you.
such a bizarre case, but it is happening in the US predominantly. But chat us through how you can take a viral trend and colloquial terms and trademark them. Can any of us do that? Can myself and Ntsako do that?
So I think I can just provide some background as to trademark law and really the purpose of our
Sure.
trademark law. Firstly, it's supposed to be distinctive of your particular goods and services. Um, Secondly, it's essentially to prevent, like you were saying, other parties from commercializing on your particular IP that you've developed and really using that reputation to their commercial advantage. When it comes to whether or not anyone can use a particular phrase, technically, yes, all phrases are usable in the sort of colloquial sense. There may only be an issue when it comes to the commercial aspects that may attract.
Luyanda, I hope I'm corrected if I'm wrong, and I hope it's the right person. But I remember when
Mm.
a particular radio station, created, or one presenter created a theme, or rather a feature on a radio station, right? And that feature exists to this day, even after, the presenter has left. And how do you protect IP, especially as one, a freelancer, or two, as an entrepreneur? Because sometimes we put out ideas and we don't actually understand the impact of them in the long run. I mean, hot girl work is something that we even say casually and colloquially during our day, but we don't even understand the impact of the loss that the creator experiences.
Mm. Well, you see, there's different ways that you could protect your IP. You could either do that through copyright law or through trademarks. The main difference being that trademark law is now going to protect your goodwill and your reputation in that particular IP, whether it's a mark, it's a phrase, it's an image. Whereas copyright law is going to protect the artistic work that you've created. So your music, your art, your books, anything of that nature. So I think depending on what you're aiming to protect, um, the protections that you're going to get are slightly different. Copyright, that is inherent. You do when you create your work and it is now written, it's recorded, then you have copyright protection. Whereas with trademarks, you will have to register your particular trademark. When it comes to phrases in trademarks, now then you'd have to be more specific as to the class in which you want to protect your particular phrase in. So if you wanted to protect it in the entertainment space, you would have to register in that particular class versus protecting it in the technology space, for example, because that would have a very different distinctive characteristic for your particular brand.
Leander, how does jurisdiction work in this particular case with the Hot Girl Walk situation? Are we allowed to use Hot Girl Walk in Africa and South Africa, or is it primarily in the US that this applies?
So with trademarks, it is territorial. You would have to apply to have your trademark protected in different jurisdictions. If you are not using the term in a commercial sense, then absolutely you can use that particular phrase. I think it would only be a concern if that company or person who's registered their mark has attracted a particular reputation within your jurisdiction. So that's something else that you'd have to consider to see that within that particular class, maybe you guys are in competing industries. In that particular class, they have significant reputation in your jurisdiction. Therefore, they might argue that they've attributed or they've gathered certain reputational rights within your particular territory. and therefore you are infringing on their rights.
Sure.
But in a non-commercial sense, you're absolutely fine to use it.
Do you think we are, as a people, active enough about what we put out there? And I ask this because there's so many trends that we put out, and people are watching. You know, these brands are watching, and they use them because they feel like, you know what, you're not going to do anything anyway. You don't know the law. Do you think there's enough information about what we should be doing if our information is out there or if it's being used in a commercial sense? And two, do you think we exercise enough of our rights around that?
I'll start with the second point. I think a lot of the time you're right in that people don't think about the commercial value of the ideas that they're putting out there. I think it's very easy for commercial businesses to see something very popular and then now create an IP portfolio around it before you've even had the chance to do that. A lot of the time it really comes down to when you actually registered for your particular trademark, when you wrote down your IP, when you recorded it, because that's the thing that's going to protect you. When it comes to popularity, that's often the thing that destroys your application, essentially, because you don't want something to become so popular and so common within the general public that it's not distinctive for your particular brand. So I think people would certainly have to consider the commercial value of what they put out there. In as far as, do we have enough education? I wish that there was more. I really do. I think IP is an incredibly valuable asset, particularly in the digital age. And I think you'll find that building your IP portfolio early and thinking about the impact that that might have, especially if you are someone who wants to have a digital career or really any career that might involve IP, it's certainly worth considering and protecting.
So, Luyanda, when you're proving your case for your particular trademark or intellectual property, do you have to be the person who was first to coin the phrase, or is it the first person who legally put it into, a legal framework for it to be my IP or trademark? Because that's also the argument here, is that just because she's done it legally doesn't mean that she's the originator of the hot girl walk phrase. And that's also bizarre to me, that you can just wake up one day and decide that this is the thing that you're going to make a business out of, but it's not your original idea.
There was actually quite a debate around whether the person who first invented something should be the one to claim all the rights, or whether the person who filed first should be the one to claim the rights. And unfortunately, we are at a stage where it is the person who files first who gets the protection.
That's insane.
There was an interesting case with the name Katy Perry. A lot of celebrities like to trademark their names or anything like that. But where you are an individual who has the exact same name and you've used it in your business, now you have an issue of, how do I go up against these huge companies or celebrities who have much more financial backing than I do? And it is something that is difficult. It will take a lot of effort on the back end, depending on your legal team, to make sure that you can secure those rights. But it's certainly possible.
I remember the Katy Perry case. It was with someone in Australia who had the same name. Imagine.
Yeah.
For me, it's this is reminding me of Megan Thee Stallion with Hot Girl Summer. Like, it's literally Hot Girl Walk, Hot Girl Summer. So I'm like, wait, we've been hot girling for the longest time, guys.
All
What
our
is going on?
It's so bizarre.
Luyanda,
That's true.
thank you so much for joining us and giving us some insight on that, because really, I think there's a lot of things that are shocking us. And you're right. I mean, even with on-air personalities, for example, we create, phrases and terms for people to relate, but we don't even realize that within itself is our IP. So that's some really good insight, man. We're gonna be calling you after this, girl.
Luyanda, where can we find you? Hopefully you've got a TikTok page that we can follow. What's up? Where can we contact you?
I don't have a TikTok page, but you'll find me at PPM Attorneys. I'm very, very active on the LinkedIn page, so you feel free to pop a message. I'll definitely respond.
LinkedIn is good enough. We will definitely be in touch. Thank you so much, Luyanda Maema, who is a candidate legal practitioner at PPM Attorneys, talking to us about all things hot girl walk that we are now not allowed to use.
So now what am I going to do?
Money.
A cold girl walk.
Imagine. It's not the same.
It is 3:30 Central African time. Zai, come to the front, baby. There's no way we are celebrating this without you. Are you kidding me?